So the first thing is the Sunshine Law is just a general reference to the law that provides for public access to governmental proceedings at state and local levels. Unless there is a statutory exemption, then it applies to any gathering of two or more members of the same board to discuss some matter which will foreseeably come before that board for action. So, for examples, members of the county commission, two of them can't get on the phone together outside of a public meeting or meet together and talk about the budget process that's coming up. But they also couldn't get together and talk about what the impacts might be if the state modifies some type of budgetary line item that was going to come to the counties, because that is business related to business that might come before the Board of County Commissioners. If the state is considering increasing funding to local counties for road paving projects or something like that, then the board members getting together and discussing it arguably meets the definition of discussing something that may come before the board for action. Now, the scope of the Sunshine Law isn't just meeting in person, as I said. Members can't engage in private discussions with each other about board business electronically, email, texting, telephone, and that's, of course, in addition to meeting in person. So it may seem like, a common practice of texting a friend about an event that's coming up, or what are your thoughts on that? That's just something that you can't do with members of your board about things that will come before the board or have the potential to come before the board for action. It doesn't mean you can't communicate with your other board members. Board members are oftentimes friends with each other, so you can talk about, kids, weather, jobs, you name it, anything you would normally communicate about, but just not anything that may come before the board or has the foreseeable chance of coming before the board. Now, that doesn't prohibit board members from discussing things with staff. All right. So the board is the decision-making body, and so they are the ones that are prohibited from talking with other decision makers on the same board outside of a public meeting. But you can communicate with staff, they can update you. But two board members can't be meeting with one staff person at the same time, because then you've got a gathering together of two board members. Now, the staff members can't be used as a liaison to communicate information between board members, because that is an end run around the Sunshine Law. And oftentimes we hear it referred to as polling. A board member can't ask a staff member to go and we'll see if the other four members would vote in favor of something like such and so and such and so. That would not be lawful. That would be a violation of the Sunshine Law. So the basic requirements: meeting of public boards or commissions must be open to the public. There's got to be reasonable notice to the public of the meetings, and there must be minutes of the meeting prepared and open to public inspection. Staff meetings are not typically required to be subject to sunshine. So if the city manager and the city finance director are meeting and discussing expenses or particular line items or preparing the budget or things like that, that's not a sunshine meeting. It's not required that the public be put on notice of that meeting and be able to attend it. But if you had two members of a city council that wanted to attend that meeting, then there would be notice to the public required, and the public would be allowed to attend. There are exemptions to the Sunshine Law, and those are created by statute. They are always narrowly construed. So in the event you say, well, I wonder if the Sunshine Law would cover this, or if an exemption would cover this, you should always assume that the Sunshine Law applies. If you have to ask the question, does the exemption apply? You should assume it does not, unless you are directed to the contrary by your legal counsel. And so if you run into a situation where you have to ask that question, does an exemption apply? Then you should pause what you're doing and reach out to your legal counsel and say, I need an opinion as to whether or not this or that or the other would be covered by sunshine law and what the rules are governing that. Now, it's also, we hear referred to, we hear public officials talk about, well, we're going to have this meeting in executive session, or this, we need an executive session. That would mean something closed to the public. And that's often misunderstood. There are only few limited exceptions where that's even an available option, and it's technically only temporarily closed to the public. The public may not be there, but there are requirements on the agency to have a court reporter present to transcribe every word, and then as soon as the sensitive item is no longer sensitive, and there are time frames involved with that, then that transcript would become part of the public record and the public would have access. So a common example of that is a municipality is engaged in a lawsuit, and the attorney for the municipality needs to get the direction of the board, but it doesn't need to be up in the public, because then the person that's suing the municipality can kind of hear them discussing their strategy. And so a session like that would be closed to the public. There would be a transcript, court reporter there that would transcribe everything, and there are certain notice requirements letting people know that there is going to be one of these closed meetings. The public records law is similar to the open meetings law, and it provides access to almost all records of the government, local or state, unless there is a stated exemption. As a general rule, the board members should assume that anything and everything related to their board service, whether it's a text message, an email, or a document, is a public record. Unless you are given guidance to the contrary by your attorney, you should treat it like it's a public record. If you are texting, even if you're not texting another board member, if you are texting with a staff person about public business related to your board service, so a commissioner is texting with the county administrator, hey, did you happen to see that the road over on such and so needs some work? Could you look into sending the road department out there? That's public business. So that text message is now a public record. It should not be deleted. It needs to be preserved. At a minimum, not deleted though. What that means, without getting into the minutia of the retention schedules of the Department of State, is just retain everything. Don't delete anything. And you may say, well, it's on my personal phone. That does not matter. If you are using your personal phone to conduct public business, those communications in and of themselves are public records, and you should not destroy them. So if you don't want that as a possibility, don't use your personal phone to text communicate. So what are the penalties for violating the sunshine laws? There are civil actions where the municipality could get sued, maybe potentially the individual board member, but this is the more important one, the criminal penalties section. There are criminal penalties available against people that violate sunshine. So if you are meeting with another board member and discussing business outside of a noticed meeting, or you are emailing with them about business that may come before the board, or you are text messaging with them about business that may come before the board, technically that is a misdemeanor. You can be charged with a crime. We don't hear it happen all that often. Usually that sort of thing is going to come up if there is an ethics commission investigation and they find that there were violations like that, then the ethics commission will refer it over to a state attorney's office, who will then look over the facts and may charge someone criminally, and it does happen. Or for instance, two board members were texting back and forth about the meeting, and then they decided they were going to delete their text messages. Well, because those messages were about a public matter, they are public records, and when they were deleted, a public record was destroyed. As for suspension or removal from office, that would come through the Ethics Commission and then subsequently the governor's office. And for violating sunshine, you could potentially be suspended or removed from office.